It has been so wonderful to know that in recent years, more and more women have felt the freedom and have had the opportunity to share their hearts, particularly those who have had an abortion in the past. And what we are finding is that through the internet, many of us as post-abortive women are able to go on and share our hearts and encourage one another. And it is amazing to know there are literally thousands and thousands and thousands of women who are saying, I'm not going to be silent anymore. And I just thank you, Natalie, for being one of those who is a voice for those who perhaps yet have not gotten the courage to come forward and say, let me speak too. Our next speaker is the reason that I am here, and perhaps Natalie as well. And I just would like to just go on and on and on about Harold Cassidy. I will share from his bio. But Harold Cassidy is a man that is pro-woman and for the rights of women. And I found that out about him after speaking with him for about 15 minutes the first time I ever met him. And I knew this is a guy who can lead the way for life, because he understood that it was not just about the baby. It was also about the woman. And he had seen so many broken hearts, broken bodies, broken minds, and he was willing as a man to step forward and say enough is enough. Harold Cassidy is the attorney of record for the plaintiff in Acuna versus Turkish, the Watershed, New Jersey case that pits the human and legal interest of a pregnant mother against the conflicting interest of abortion doctors, who until now have claimed to have represented the interest of women of the nation. Mr. Cassidy is a partner in the New Jersey law firm of Cassidy, Messina, and Lathy. He has been designated by the New Jersey Supreme Court as a certified civil trial attorney. Mr. Cassidy has litigated cases of public interest, such as in the matter of Baby M, which was the first case in the United States to strike down surrogate parenting contracts as illegal, unenforceable, against public policy, and exploitive of women. The case culminated a decade of work on mothers' rights cases. For his work in surrogacy, he was selected Person of the Week by ABC World News with Peter Jennings. Mr. Cassidy has been the chief counsel of many cases of public importance, including the leading case in New Jersey, which established the right of a person accused of a crime to be represented by independent counsel. He successfully defended the first post-bank closing due process hearing in the history of New Jersey. Mr. Cassidy was also a member of the legal team, which represented Reuben Hurricane Carter, which won Mr. Carter his freedom after 19 years of court proceedings. He has lectured widely on the rights of women at many law schools and universities, including the Harvard Law Forum, Yale Law School, and Princeton University. He was appointed by the governor as a member of New Jersey's Bioethics Commission and was a delegate in the American Bar Association Conference on Life, Death, and the Law. He has appeared on national and international television, including Nightline, David Brinkley, and David Frost in London. So without further ado, a man who has tirelessly fought for the rights of women and unborn children, Harold Cassidy.
Thank you very much. Aren't they great? I'd like to thank Matt and Liz and all the members of the Princeton University Pro-Life for having us. It's, as I often say when I go out, probably the most enjoyable part of my job, probably because it's not part of my job, is to be among the people and talk. And those who've heard me speak before have heard me fondly remember the time I was invited to go over to Rome and speak at an international conference, and I thought it was a great opportunity because it was the one chance I thought that I'd get away from the lawyer jokes. because that was a uniquely American phenomenon, and there would be no lawyer jokes in Italy. Unfortunately, an American introduced me and said, a lawyer and a pope showed up at the pearly gates of heaven at the same time, and St. Peter was there to greet them and turned to both of them and said, we've been waiting for you when we prepared your houses. He turns to the Pope and he points out to this modest home up on a hill, and then he points it out to the Pope, and he turns to the lawyer and he points to this huge mansion and says, this is the home that's been prepared for you. And the lawyer stops in his tracks and says, wait a minute, there's got to be a mistake. I'm only a lawyer. This is the Pope. And St. Peter says, look, there's been no mistake. And they walk a little further, and the lawyer stops again. He says, look, there's got to be a mistake. This is the Pope, and I'm just the lawyer. St. Peter loses his patience a little bit, says, look, we don't make mistakes here. We have lots of popes here. So I gave the talk anyway. Now, the reason I came here to Princeton to talk today, of course, is to talk about what may very well be the greatest human rights violation of our time, and our duty, and the duty of everybody, to end it. And I'm talking about the devastating, life-altering event when an abortion doctor terminates the fundamental right of a mother in her relationship with her child, ends that relationship by terminating the life of the child, and ends it irrevocably. There are two separate aspects to this particular problem. There are the experiences of the mothers, those everyday experiences that the courts seem to be so far away from, that the courts act as though they are totally unaware of. And then there's the constitutional jurisprudence that has grown up in this country under the name of the rights of women. 30 years ago, abortion was viewed as a remedy. It was a remedy for this perceived uneven burden that unplanned pregnancies presented, a burden that the mother had that the father did not have. It began usually with a man exploiting a woman sexually. It continued when the man abandoned her, left her alone, isolated, to come to grips with her decision of what she was going to do. And of course, the woman being left with the frustration that the goal for her child, that we hold for every child, that a child is born into a family that's loving, that prepares for the child, that wants the child to be raised by both parents. And at that time, there was one decision that the mother faced. She had to face the decision of raising a child alone, with the father abandoning her, live with the stigma, live with the poverty that it would bring, or surrender the child the rights, what our Constitution has called the oldest liberty interests that any woman has in life, a right to have a relationship with her child. Give up that right. The emotion, the pain, the isolation, the separation for many women were awful. And in my practice, 20 years ago, 22 years ago, 23 years ago, I had occasion to represent women who gave up their rights, surrendered their rights. Some of them felt they were lied to, they were forced, they were induced, they were tricked. Some of them came to me because they wanted to get their babies back. Some of them came to me many years later because what they wanted was much more modest than that. It was a society that said that this child was the most precious thing in the world for some people. But it was a society that told the mother that she had to get out of the life of her child because her child was better off in life without her. Can a mother in the audience think of something more painful to be heard? I'll tell you one story of one of the women who I represented. Her name was Erna Moore, and she came to me in her mid-60s. In the 1930s, in Jersey City, New Jersey, she became pregnant, senior year of high school, and her father forbid her to bring the child home. Lectured about the disgrace it was to the family. Of course, the father of the child wanted to have nothing to do with her. And she went off to the Margaret Haig Hospital, this monument that Mayor Haig had built to his mother. And there in maternity ward, with all of the joy that motherhood brought to all the women around her, she was there in her isolation and no one would come to visit her. She had no place to go. She begged people to let her go somewhere with her child, but in 1938, she was told that she was being selfish. And she tried to stay in the hospital, and when they told her they were going to kick her out on the street, and the adoption people came around, she signed a relinquishment document that she couldn't even read through her tears. So she comes to me because she wants to get to meet her daughter before she dies, somehow, to tell her she loved her. So in those days, it was a little bit unusual, but we went into court and we won a court order that said that the first appointed an intermediary and said that the agency and the state had to turn over the identifying information to this intermediary. And when they located the daughter, who was an adult now in her 40s, if she wanted to meet her mother, and only if she wanted to meet her mother, it could be arranged. And time went on. The information was old. The records were incomplete. And I got a call from Norma one day, and she was losing hope. She was in the hospital in New York, and she was very sick. And she had one other child in life, and she had gave everything she could to that child. But she had changed. She had her will, which should leave what she had to the child who she never raised, who she gave up at the Margaret Haig Hospital. And on this day, she called me to say she was tired and old, and she thought she'd never get to see her daughter before she died. And I, of course, encouraged her and told her that wasn't true. Everything was going to work out. Of course, I didn't know if I believed that or not. But she said she had changed her will back. A little while after that, maybe 10, 12 days later, I got a call from the intermediary, and she told me that she had found Erna's daughter. And it was a rush of excitement to think of what that would mean to Erna. And then I was told that Erna had died 2 days earlier. And her daughter came to me to meet me, to touch me, like it turned out her wonderful adoptive parents had already passed away. And her daughter had been searching for her, and they had been looking for each other. Those who proposed abortion as a remedy had that experience in mind. Now, in this context, the law was developed, highly developed. There were horrific stories of women being forced to give up their children, and so the law protected in trafficking of children. And one of the great victories of the law is that it said that a pregnant mother had this right, and no one else had the right to violate it or to interfere with it. It was her decision of whether she was going to surrender what we in the law call the liberty, the due process liberty interest that a mother has in her relationship with her child, which is probably the greatest liberty interest that any woman has in all of life. And the law guarded against pressure to ensure that these were voluntary decisions, to ensure that they were informed decisions. And the laws in our state and in all the states in the Union require counseling so that the surrender of this great right is a last resort. Not a first option, but the very, very last option. That a civilized culture doesn't take a baby from a mother unless we've offered all the help we can to keep them together. And only if it's her decision, and it's truly informed, and she understands her options, and it's truly voluntary. And in that context, every state says that the waiver of that fundamental right cannot be recognized until after the child is born. This is for the benefit of the mother as well as the child. And until she can see the child and she has a full, unabridged appreciation of what it is she's giving up for herself. And in our state, in the Baby M case, our Supreme Court said that any decision during the pregnancy is uninformed as a matter of law. There were times when a woman wanted me, when someone violated the rights of these women, and they wanted me to go to court and fight to get the baby back. We actually, as hard as the cases were, as emotional as they were, and as gut-wrenching, when we could show that their rights were violated, we could get the babies back. At the very end, one of the last things that Erna Moore ever said to me, she read a story in a newspaper that there was a woman out in the Midwest, I think it was Indiana, who called herself Elizabeth Kane, who became the first surrogate mother. And she looked at this, read the story, and she said to me, they're forcing this woman under this contract. They're planning this separation. Do you believe that they're planning this pain on purpose? They're planning to do this on purpose? When I was arguing the Baby M case a few days before we were going to the Supreme Court, I received a call from a judge out in California, a woman who asked me about the record. She was interested in knowing what was in the record and whether the bonding information was in and what kind of scientists we had testify. And we talked about it lawyer to lawyer. And then she started opening up, and it turned out she too was a birth mother. Marvelously accomplished woman. She had surrendered a child, and she now was trying to make up for it. And she said to me, at the end of the conversation, she allowed herself to be calling me by my first name, and she said, Harold, do you believe that people want to do this on purpose? And so it's an age-old problem of people for their own motives, their own interests, want to separate mother and child and to exploit the circumstance that puts a woman in a position where she's vulnerable to exploitation. Now, in contrast to the law that has grown up to protect the rights of pregnant mothers from that uninformed, involuntary waiver, we have our abortion jurisprudence that has come down from the United States Supreme Court. Now, this remedy that has been proposed, it was in 1973, and there were two cases on January 22 decided by the United States Supreme Court. One, of course, you know, is Roe versus Wade, and the companion case is Doe versus Bolton. The plaintiff in a Roe case was a woman named Norma McCorvey. Roe v. Wade was the pseudonym that was used. The woman who was the plaintiff in the Doe v. Bolton case that was decided the same day, her name was Sandra Cano, and Mary Doe was the pseudonym that was used for her. But the real parties in interest, those women never testified. The real parties in interest were the abortion clinics and the abortion doctors who joined them as plaintiffs. Now, the Roe v. Wade decision came down, and you will probably remember that it was a 7-2 decision, and it was 7 crusty old men who decided that without a record, without any understanding of the experiences of women, we hadn't experimented, after all, with legalized abortion at that point. Without any findings of fact, they decided, and without any discussion of the oldest, most precious, fundamental liberty interest that a woman has, no discussion, they decided that the remedy was going to be legalized abortion, and they placed it, and they entrusted this in the hands of the abortion clinics and the abortion doctors. Now, divert 1 second, because it's important to understand the origins of Roe v. Wade. You remember Justice Marshall? When he passed away, his papers were made public a year later, and there were many anecdotal tales in the papers that embarrassed the court. And one of them that was widely published was Justice Marshall explaining 2 cases, Roe versus Wade and Planned Parenthood versus Casey, which reaffirmed Roe versus Wade 19 years later in 1992. Justice Marshall told the story that it was voted in conference to create this legalization of abortion, declaring Texas's statute unconstitutional, and it was given to a new justice to the court at that time, Harry Blackmun, to justify the conclusion. Here's where we're going, figure out how we're getting there. And he was alerted to a little-known decision that was decided by a district court judge named John Newman in the state of a district court, in federal district court in Connecticut the year earlier, in 1972, in a case called Abel versus Merkel. And it was suggested to him that he read that case and use that case as the model for Roe. And any lawyers who ever read Roe v. Wade who went back and looked at Abel versus Merkel would recognize Roe in the Merkel case. But there's 2 interesting aspects to that case that's very illuminative. One, in his opinion, Judge Newman said, and this is a quote, it's easy to remember, "The universality of thought about the nature of the fetus cannot be imposed upon the mother." So what he's saying is, we all know that this is a human being, as a matter of fact, but we're not going to tell that to the mother, the woman, and we're not going to try questions of fact in his courtroom and bind litigants with questions of fact, which is probably the most bizarre proposition that any lawyer would probably have ever heard of. So he says, even though we all know the truth, we're going to ignore it. The second thing he said was viability is irrelevant. He had a record before him in which there were post-viable abortions. And despite the best efforts of the doctors, some of the babies lived, some of them without limbs. And so we had a record with these children alive, and he says that although if a child survives the procedure, the child may acquire due process rights. The fact that you can't ensure success after viability doesn't mean that the child has any rights, and so viability is irrelevant. Now, what Roe v. Wade did, what Justice Blackmun did when he addressed those two things, is he says, well, wait, we need an opinion that the people will accept. We can't tell everybody that we all know the truth, that this is a human being, so he has to say the reverse. He can't say it's not a human being because that's absurd. So what he says is we don't know. And the whole basic premise of Roe versus Wade is that in the year 1973, science could not say when the life began. As to viability, the court knew that we couldn't have children running around with no limbs, and so they used viability as the point at which, and this is what really tells you what the nature of the procedure is, that the attempt to terminate the life of the human being will be successful, so that viability, in talking in terms of the state's interest, the state has an interest in prohibiting abortion. That's where this began. The problem is that the underpinnings of Roe and the assumptions of Roe is that there's no understanding of what the woman's experience is going to be. We have no idea what the physical harms are going to be, what the psychological harms are going to be. It really represents, for the most part, what we would like women to do, especially the men. Get sexually exploited, kill your own child, and forget about it. Act like us. It gives to the abortion industry solely the trust to do what is necessary to try to make the decision informed and voluntary. And it assumes that they will counsel. It assumes that they will provide information. It assumes that they will ensure voluntariness. And the biggest problem of all is that there is this gaping hole that someone like myself is looking for. Where do we factor in the destruction of the mother's most important liberty interest? That's where it all began. Now, the cases that we're going to talk about in a moment are the first cases in this country that in the abortion context have raised the mother's fundamental interest in her relationship with her child. It has never been raised before in 29 years of abortion jurisprudence. But it shouldn't be a great mystery. It shouldn't be a great mystery why the mother's real rights have never been raised. Because in the year 1976, in a case called Singleton versus Wolf, the United States Supreme Court announced that the abortion industry could jettison the women themselves. The Norma McCorveys and the Sandra Canos were no longer necessary to be parties, and that the abortion doctors and the abortion interests 26 years ago could appear in cases all by themselves, and they would be given the legal standing to litigate what they, the abortion industry, claims is in the rights and interests of the women of the nation. And the court has heard from nobody other than the abortion clinics and the abortion doctors. The states, for their part, have been raising states' interests about potential life, and neither the states nor the abortion industry has served the interests of women well in these cases. And consequently, there is this gaping hole. When the Stenberg case was decided, it was a single abortion doctor who claimed what was in the interest of women. When the Casey decision was decided, it was Planned Parenthood who was telling the courts that they knew what was in the interest of women. Sandra Cano filed an affidavit in one of our cases in which she tells the story, the real story about Doe versus Bolton. She was a mother of 3 and she was pregnant and her husband deserted her. And her stepfather and mother took them in for a little while and demanded that she have an abortion. And they made an appointment at a hospital, and then they hired a lawyer to file a complaint to get the court to say that the hospital had to give her an abortion. When Sandra Cano found out what her mother and this lawyer had in store for her, she left the state of Georgia and went to Oklahoma, where she stayed for 3 weeks to avoid an abortion. This is how this began. She signed an affidavit in our case telling this story, and she came back from Oklahoma. She was impoverished, and she cut a deal that if she sat in the back of the courtroom and shut up and didn't say a single word and didn't testify and let the case go through and let the court decide what the court thinks is in the interest of women, then they wouldn't make her get an abortion. And so she cut her deal and she didn't have an abortion. And she never signed an affidavit. And a few years later, when she found out in the news, because her lawyer never communicated with her, that Doe versus Bolton was decided in her name, she became so depressed and upset that she was responsible for children dying and for women suffering the same plight that we heard today. She went to court because she wanted to see what was in the record in her own case, and her own lawyer who represented her in Doe v. Bolton opposed her. Because when it was opened and she discovered what was there, there was an affidavit with a forged signature in her name. It was a fraud on the court from the beginning. Norma McCorvey signed an affidavit in that same case, and she tells the story that somebody recruited her when she was pregnant to be a plaintiff in the case in Texas. And she never even knew what an abortion was. And they sat around over a pitcher of beer for 2 hours and came up with the name of Jane Roe. She heard from a lawyer one other time. They asked her to come in and sign an affidavit, which she did, but she didn't read, and she never heard from the lawyer again. So it's no great wonder she learned about the outcome of the case in the newspaper. It's no wonder why in Singleton versus Wolf, the abortion industry wants to get rid of the women. They're just unnecessary baggage. Incidentally, when Roe versus Wade was decided and Doe v. Bolton was decided, it was supposed to have been to protect the interests of these 2 women. The district court in New Jersey recently told these 2 women that they have no interest in any of the abortion litigation, even to the extent that they wouldn't permit them to so much as file a friend of the court brief. Now, before I talk about Acuna, I have to talk about Planned Parenthood versus Casey, because 19 years after Roe was decided, the Supreme Court of the United States reaffirmed the central holding of Roe v. Wade. And it's important that when we talk about today in context, the historical context of any cases going on today, that we understand the decision in that court. The question becomes, one question is, why was it reaffirmed? And it was reaffirmed not because Roe was correctly decided. In the Marshall Papers, but Justice Marshall tells the story that 3 years before Casey, in the Webster decision, that there was a 5-4 vote in conference, in a preliminary vote, to overturn Roe versus Wade because it was incorrectly decided, just based on the state's interest analysis. And I don't want to bore you people, but the states were claiming that they had their own interests and they had the right to choose for themselves whether they wanted to ban abortion or not ban abortion. The abortion industry was saying, well, we represent the rights of women and we know what's in their legal interest, and they have an interest in terminating a pregnancy. When Roe versus Wade was reaffirmed by Casey, it was done so with a court where 6 of the 9 judges had voted to overturn Roe because Roe was incorrectly decided. In the Webster case, there was a 5-4 decision, and it was Justices White and Scalia and Rehnquist and Kennedy and Justice O'Connor had voted to overturn Roe because just based on the state's interest. And when Rehnquist was writing what became the plurality opinion in that case, which upheld the statute that was under scrutiny, he thought he was writing a majority opinion overturning Roe. Justice O'Connor took her vote back, and Justice Marshall tells the story of all the pressure she was put under, most notably by Justice Blackmun. And the contention was, if you are anti-abortion, you are anti-women. And Justice O'Connor was not able to overcome that perception. There are anecdotal tales that after that opinion was published, she went off to Ireland, she vacationed and crashed for 2 weeks, and all she could talk about was how she couldn't stand the pressure of the abortion industry, and she had the issue. She had to get out of Washington, D.C. 3 years later, Roe was again, and Casey voted to be overturned in a 5-4 decision. O'Connor was done. She had fallen by the wayside, but there was a new judge on the court, and that was Justice Thomas, and he joined the other 4 in the preliminary vote. Only this time, it was Justice Kennedy who changed his vote. And they then wrote, Justice Kennedy and O'Connor, joined by Justice Souter, wrote what became the plurality opinion, which is called the joint opinion, because the 3 of them wrote it together, and we don't know precisely who wrote which parts. But it was a decision that is one of the great, truly great and odd decisions of the history of our Supreme Court, because it was a 2-3-4 decision. 4 judges wrote that Roe v. Wade was incorrectly decided and had to be overturned. Only 2 judges were willing to say that Roe v. Wade was correctly decided, and the other 3 judges said that we do not have to decide how this case as though it was before us for the first time. They said that what they had to do is, and I'd like to read the words because it's, here's what the judges said. We do not need to say whether each of us, had we been members of the court when the valuation of the state interest came before it as an original matter, would have concluded, as the Roe court did, that its weight is insufficient to justify a ban on abortions prior to viability, even when it's subject to exceptions. We are satisfied that the immediate question is not the soundness of Roe's resolution of the issue, but the precedential force that must be accorded to its holding, which means, they said, it's more important to be consistent in our decisions than it is to be correct. And there is such a, we call that stare decisis. And in the stare decisis, what they said, the reason we're going to uphold a decision that might even be a wrong decision is because we can't figure out any way to justify to the American public the reason other than to say it was incorrectly decided, and it would appear too political that just by mere dint of numbers, conservatives simply say we think it was wrong. And so they justified upholding it, saying that we have to look at stare decisis and figure out if we can satisfy a single prong of the rules of when we can change prior decisions. And they say, we can't because, one, Roe is in no sense unworkable, they say. They say the people of the nation have come to rely on abortion in organizing their relationships. And they say, and this is the one that fascinates me the most, probably takes most of my time, courts building upon Roe would not be likely to hand down erroneous decisions as a consequence, even on the assumption that the central holding of Roe was in error. That error would go only to the strength of the state's interest in fetal protection, not to the recognition afforded by the Constitution to the woman's liberty. So here's Justice O'Connor's problem with the perception that if you're anti-abortion, you're anti-women. She can't figure out how Roe's error has affected the rights of the women. She can only see how it affects the rights of the child. And of course they say, well, there are no new facts or new appreciation of old facts which would undermine the validity of Roe. And that's why you have Roe versus Wade reaffirmed. The problem is that all of that, all of those conclusions, all of those justifications are in direct defiance of the reality and the experiences of women. What they didn't do, because they're listening to the states talk about their right to choose, and they're listening to the abortion industry saying we're going to pick and choose over which rights we want to present for women, and we are the ones who are going to be the sole presenters of the rights of women, they ignore the woman's real right. Abortion isn't the exercise of a right. It's the waiver of the most important fundamental right that a woman has. The Acuna case is the beginning. Rosa Acuna, and there are two other women in the state of New Jersey, and today there's a woman in Oklahoma who filed a complaint. They've started a new women's movement. When these women came to me, unlike in the other contexts, when someone violated their rights, we could get the baby back. When these people violate the rights of the women, we can't get the baby back because the people who violated their rights have killed the baby. And it doesn't matter what we can prove in court. And what the Supreme Court has assumed, the basic assumption, without ever discussing it, without any record to support it, is that the waiver, or whatever the mother's doing in that abortion clinic or at that doctor's office, is truly informed and it's truly voluntary. Rosa Acuna has a case against the abortion doctor in New Jersey that is coming up for trial. Part of the case is in the appellate division because in an unusual or rarely used procedure, the appellate court has reached down and taken some of the constitutional issues at the same time that the case is going on, preparation for the trial, in which Rosa has accused the doctor of doing an abortion without a valid, informed consent. Rosa was a 29-year-old woman, married, had 2 children. One daughter was 2.5 years old, who was born by an emergency C-section. Her second little daughter was born 9.5 months before the facts of the case by a repeat cesarean section. And she went to a regular gynecologist, the mother of 2, the wife of Andres. And she went down to a regular gynecologist who had been her gynecologist for 5 years, who had delivered the second baby because she had abdominal pain. And when she got there, the doctor examined her, did a sonogram, and announced that she was pregnant and told her she should have an abortion. She asked that doctor one question. The only thing she wanted to know is my baby already there? She wanted to know, she's been deposed, and all she wanted to know was, is this a human being here, and are we terminating the life of a living human being? And this doctor, who had the superior knowledge, belittled her and told her, don't be stupid, it's nothing but some blood. He said it was nothing but tissue. So 3 days later, or 2 days later, she comes back and signs a piece of paper that says, I give Dr. Turkish permission to perform a TOP. And there's no further discussion except she asks the question again, and he gets angry with her and says, I told you not to be stupid. And so they do the abortion. It doesn't feel right. She sits through it, and she goes home, and she starts bleeding, and she bleeds on and off for 3.5 weeks until she has a massive hemorrhage, and she's rushed off to Robert Wood Johnson Hospital, where she's examined and she's admitted. And while she's lying on the gurney, she asks the nurse, what's wrong with me? And the nurse says, they left part of your baby in you. So she can't reconcile what the doctor said and what the nurse said. And this woman, who was born in Puerto Rico, speaks English very well, but never graduated high school, went down to the library and started reading about the science, the development of the child, and before long she realized that the doctor had lied to her. She became depressed. She ruminated. She thought about her own role in it. She blamed herself for being stupid. She blamed herself for relying on the doctor. And what she didn't know was that that gynecologist who she trusted, who cared for her and her babies, had worked in an abortion clinic for 10 years. And 14 months later, she wrote a song to the baby after she was going through counseling. She arranged it. She sent it down to Costa Rica, saved money, and recorded it in her own voice after 22 months. And then a month and a half later, at the urging of friends and family, she went to a lawyer and she instituted a suit against the doctor. And she sued the doctor for the wrongful death of her child, because the law says in New Jersey, in other states too, but it varies from state to state, but the law says that a doctor, any procedure, has to tell a woman or any patient the nature of the procedure and any facts that a reasonable and prudent patient would want to know or consider relevant to that particular decision of whether or not to have that procedure. And so Rosa Acuna has sued in uninformed consent, and she has said that, number one, a first trimester abortion terminates the life of a living human being, and number two, and a jury has to decide that question, and number two, that is a fact that a reasonable, prudent patient would want to know before they decided whether or not to have that procedure. Sued him in wrongful death survival action, the emotional distress for the loss of the child, and for the injury to herself, all under uninformed consent. And it implicates some questions, but what is really at the heart of it is the question of this particular case. First time it's being raised. Whose decision is this? Does a woman, when she's waiving the most important liberty interest she has a right to have an informed and voluntary decision? Or can the doctor, as in this case, in depositions, he says, well, this is not a human being, this is not a human being, and he said it for a day and a half until he was finally confronted and said, look, doctor, he says, you're talking philosophy. We said, we're not asking you about philosophy. We don't care about philosophy. We're asking you a biological fact. He says, oh, if it's a biological fact, life begins at conception. So what he's saying is he imposed his view of the world, his philosophy, that is a human being, but that human being's life has no value, and deprived her of the right to make the decision for herself. And here's the beauty of the case, and it makes me laugh when I think about it. The doctor says that she can't sue him in wrongful death. She can't sue him in the emotional distress claim that New Jersey has created because he says Roe v. Wade doesn't allow the states to recognize that the unborn child existed. And so the doctor, the abortion doctor, who's been claiming that they've been litigating the rights of women, use Roe as a shield against the women and a weapon against the women, claiming, in effect, that it's the doctor's decision and not hers. The lower court agreed with the doctor and said that Roe v. Wade forbids, creates in effect immunity for the doctor when he deprives the mother of making an informed decision. And that has gotten the attention of the appellate courts. So what's before the courts in these cases, in Rose's case, is who the courts are going to side with now that the conflict has been exposed. Now that the women are suing the doctors, and they're starting to come, it's a small wave of women across the country who want to redress their grievance against the doctors. Are the courts going to side with the rights of women to make an informed decision, Roe supposedly protecting a woman's right to choose? Or is Roe going to be used to protect abortion doctors who kill women without informed voluntary consent? Well, around now, I always think of that time that I saw Hubert Humphrey giving a speech to one of the Democratic conventions, and he's going on all night, as he was famous for, and just about when everybody in the place thought he was never going to stop. He says, when I left the house today, my wife Muriel said, "Hubert, remember now, a speech needn't be eternal to be immortal." I think of it, but I always think of it too late. Is Rosa Acuna here? Is she in the room? Where's Rosa? Stand up, Rosa. Is that on? Does this work? Almost 50 years ago, there was a woman named Rosa Parks who refused to go to the back of the bus, and she started the movement. This is the new Rosa. Only this Rosa not only refuses to go to the back of the bus, she refuses to let the abortion industry take for themselves the rights of women and claim that it is their sole domain, and they and only they know what's good for women, and only they can litigate the rights of women. And she, with other women now, are taking back from the abortion industry the right of women to litigate their own constitutional rights. She stood alone in the beginning, but some people are standing with her now. But whether she succeeds and other women who come after her succeeds is going to depend on the support of the rest of us, particularly the women in this room and the women across the country, and particular women who have had abortions, to speak out and speak the truth that this is not in our interest, that abortion doesn't protect the rights of women, that it destroys the most fundamental right, that there's better ways of protecting the waiver of that right, and certainly that the abortion doctors and the abortion clinics can't make decisions for them. There's one thing, if you'll give me the abortion clinics and the abortion doctors who have claimed, who are the ones that the Supreme Court has entrusted to counsel women, to be sure that it's informed, that it's voluntary. They're totally unregulated. They're totally unanswerable and unaccountable. Rosa and women in Rosa's position are the only people in this country right now effectively trying to hold them accountable. In the record in one of our cases, Carol Everett, who was mentioned by Carmen, submitted a report about the clinics that they ran and how all they did was sell abortions. And she said one of the most basic questions that a woman asks is my baby already there? Is there a human being? They want to know, and they are uniformly, systematically lied to. The doctor in Rosa's case said, yes, women ask me that question a lot, and I always say it's just nothing but some tissue. I thought they'd ask me about philosophy. But these people to whom the counseling is given, I think you'll forgive me if I read something. What I have in front of me is a portion of a transcript of one of the annual conferences of NARROW. It's in the mid-90s. And the transcript from the recording is in a seminar on counseling women about abortion. Carol Everett says, you only tell them that they have to have the abortion. We sell abortion. According to her, they got commissions based upon how many abortions they sold. They have no interest in preserving the mother's right in her relationship with her child. And I want you to listen to this as one of the parting things today on the abortionists sitting around in their annual conference talking about how to counsel women, presumably to make an informed decision. And one of them says, and this is a lecture on how to counsel. And one of the people on the dais says, and somebody started talking about God and talking about a forgiving God and all of that. And I asked her, Pamela, do you actually believe that what you're saying when you talk to your clients, when you say these things about God, do you actually believe it? I myself don't believe in God. I don't know what a forgiving God is. I mean, that's a personal thing. When I'm saying those words, and I've said it lots before in these sessions, they ring hollow to me. The loving God. So someone else chimes in, another woman chimes in, she says, I don't believe in God either. But someone's telling me they believe in God, is usually a Christian or whatever, and I say, tell me about the God you believe in. Tell me about your God. Does your God forgive? Quote, yes, okay. So what's the problem? And the audience laughs. And then another jumps in. And Sherry Krieger says, if you believe in a forgiving God, which I'm sure you do, then your God will forgive you for this. This is supposed to be counseling, not persuasion. And then this other guy jumps in, Joseph Feldman, and he says, well, I'm distracted by the issue of God. You know, this forgiving God. You don't get forgiven. I said something along the lines of, forgiving God, and then this woman said to me, I said, you're okay, so go ahead and do it. And she said, no. You only get forgiven if you've done something bad and you feel bad about it. You don't get forgiven for deciding to do something bad and then doing it. That's evil. He goes, And the audience laughs. And he says, bad strategy. So I don't do that anymore. I don't believe in doing the God thing. That's only good in post-abortion. Now I do, if God really loves you, do you think she wants you to have kids you don't want? And he continues, if God really loves you, do you think she wants you to be in a situation there's no ethical way out of? This is a loving God. Forget the loving God. Forget the forgiving God. And then the other one jumps in and says, okay, I'll try the loving God. And they all laugh. And then she says, I'm going to switch camps to the loving God. Okay? Thanks. A lot of laughter. I got it now. These are the counselors who say, I'm an atheist, I don't believe in God, but I am going to presume to counsel a woman about God. And of course, I'll figure out what's the best thing to persuade her that she has to have abortion, forget about everything else. Rosa Acuna wants the decision to be for the woman, and it begins with holding the doctor accountable, and she's going to sort out whether the court is going to say that this doctor is going to be held accountable for lying to her and taking her child from her, which she never would have done if she had known the truth. It's the only thing that mattered. It's the only thing she asked about. And she's going to see it to the end. But she needs people to work with her. She needs people to stand with her. What's your name? Yeah. Tori? Do you think people have to stand with women like Rosa? There are ways that women can stand with Rosa and other women. You can join a friend of the court brief and speak to the court. Do you want to stand with Rosa? Stand up. Will you stand with Rosa? Brooke, will you stand with Rosa? What's your name? Cecilia? Will you stand with Rosa? Who will stand with Rosa? Who's going to stand with Rosa? Thank you. I'll bet you all of this scared you, huh? If they want, yeah.
Thank you very much for all of you for coming this afternoon. If anyone has any questions, we have time just for maybe one or two questions for anyone up here. Any questions at all? Yep.
My problem is that we've learned to live with so many nightmares one after another. I'm submitting for it and everybody else does it. My cases, my problem is standing with the women for position. If a woman is then given properly, she's counseled, she's informed, she knows about her liberty interest, and yet she still volunteers for an abortion, is the state then compelled, no matter how, the abortion? I can't stay there.
The question that was asked was, let's assume that Rosa succeeds in her case, and she establishes a rule of law that says that a woman has to be counseled properly, steps have to be taken to ensure that it's voluntary, and if all of that happens, will the law still say that if a woman then makes a decision to have an abortion, can she have an abortion? And the answer is that at the end of Rosa's case, if that's as far as we go, the answer is yes. It means that for women like Rosa, there would be no abortions. But what the case does, there are other cases, and there are other issues. And the question that is now the whole dynamic that has been changed is that the focus is on this is a waiver of a fundamental right. This is not the exercise of a right. The question arises factually whether, under what circumstances, you can really have a truly informed waiver of this right. Our Supreme Court has already said that there can't be a waiver before the baby is born, that it is uninformed. The body of law that says that has never been applied to abortion jurisprudence. Rosa is starting that process, and where it leads and we're not even talking about the rights of the child. The first question that Rosa's case asks is, does a first trimester abortion terminate the life of a living human being? In the year 2002, you might be shocked to know that the courts have never answered that question. And it's not that it's insignificant or that it has no legal relevance. It is very relevant to her rights, and whether someday it becomes relevant to the child's rights is another question for another day in another case. But when Casey said, Roe may be wrong, but we can't figure out how it affects the woman's liberty. You can't say it's not workable. Rosa and Donna Santa Maria and Jane Jones and the other women who brought these cases are illustrating exactly how it's unworkable, that you can't have a constitution that's going to protect the right of the mother in her relationship with her child, and at the same time, simultaneously, protect the right of terminating that relationship by killing the child. It's impossible, and it's totally unworkable.